I am now going to turn this conversation to that's super important to legislators, and that is legislative privilege. We are fortunate to have Stephen Ogle from Texas's Sunset Advisory Commission on the line with us to talk about this. I'll just don't think it's too much of a blowing the surprise to say that there's probably less legislative privilege than you think when you walk into the realm of redistricting. Steve, are you ready to go? I haven't heard your voice yet. Are you there?
I've been on mute. I'm here.
Okay, great. Take it away.
All right. Hi, my name is Stephen Ogle. I'm the Assistant Director of Reviews and the General Counsel for the Texas Sunset Advisory Commission. And today we're going to talk about legislative privilege, or as I like to say it, executive privilege isn't for everyone. Disclaimer, these are my opinions. These are my research. This does not represent the opinions of the Sunset Advisory Commission. Let me go ahead and put a plug in. If you would like more information on legislative litigation, you should look for the NCSL tool, State Legislatures and Litigation Toolkit. Very, very useful. I help contribute to that. So what is legislative privilege and why does it matter? Well, privilege is really a judicial doctrine. It's about the limitation on a person's ability to demand information about communications or to ask witnesses about what was said. Again, this is in a judicial context. It will shield legislators from interference without carrying out their official duties. And what, in a larger context, has to be understood, that this is really an extension of the doctrine of separation of powers. You don't want the executive or the judiciary needlessly scrutinizing the legislative actions, and so that this is a shield against that. Does legislative privilege apply to state legislatures? Yes, but, and it's a strong but, you're going to have it found in most states and in federal courts to be a qualified privilege, which means that that privilege can be pierced and that courts will take a close analysis and to decide whether or not to grant a privilege. In some state courts, you will find that privilege is absolute. And I'm going to tell you this again and again throughout the slides. The state you're in matters, the venue you're in matters, and facts matter. So you need to consult with a licensed attorney in your state to know more about these facts, but these are general propositions. And in most states, you're going to find that there's a speech and debate clause similar to the United States speech and debate clause within their state constitution. What and who does legislative privilege protect? Well, it's going to protect testimony. It's going to protect the documents that are legislatively linked. It extends to floor debates. It's anything that's a part of that integral process of producing legislation. It's an extension of the member to those he or she interacts with as part of performing their legislative duties. But the way I like to visually demonstrate it is this graph you'll see here. The dark purple represents the privilege within the legislator sphere. The legislator doing his core legislative duties. He's in committee, she's on the floor discussing legislation. That's core function. That's greatly protected. Well, what about the legislative staff? Well, the courts have come back and said, well, legislative staff is like the alter ego of the legislator herself. That staff is the only way a member of the legislature can get their job done. Therefore, we need to protect that relationship and those communications as it relates to core legislative function. Well, what about the committee staff and agency staff? Again, they might very well be necessary to completing the work, but you're now going to start to get a more questioning approach from the courts. Is it the clerk of the committee who is just in the room, or was it the general counsel for that committee providing legal services necessary to render legislation? Those fact questions become really determinative when you're at the committee and agency staff level. And then finally, you have members of the public and advocacy groups. While it is possible that legislative privilege will extend that far, the reality is that in most cases, there will not be a legislative need to such an extent that that protection will be there, but it is possible. So it's, as it's visually described, shows, it's spheres of influence. What does legislative privilege not protect? Well, first of all, it's got to be in the legislative arena, and it's got to be about core legislative duties, which is really about enacting legislation or setting appropriations. It doesn't cover constituent newsletters. It doesn't cover media briefings. It's not really about the political aspect of getting elected to be a member. It's about that core legislative function, which is passing legislation. It also doesn't cover ministerial actions, meaning if a member has no discretion in doing the activity, they have to do it, that is not covered. The lawyers in the audience would tell you that, yes, criminal conduct usually is not covered by privilege. You cannot use privilege to hide your criminal activity, no matter which privilege it is. So that's not going to work. And of course, factual reports, documents created after the legislation, that didn't help create the legislation. It isn't informing the process, and so is not protected. So this slide I like to focus on because even seasoned attorneys sometimes confuse the difference between confidentiality and privilege, and they'll use the terms interchangeably, but they're not truly interchangeable. Confidentiality is about the nature of the information you're describing. A person's social security number is confidential, but if it's printed on a sheet of paper with their name, their address, and the last 5 times they went to the ballpark, only the social security number on that page is confidential, and it needs protecting. But the document itself, in its whole, and whoever they submit it to, there's nothing else beyond that, just the social security number. Privilege is very different. And the slide uses the example of the doctor-patient. We want patients to feel free to speak candidly to their doctor so that they can get a fully informed medical opinion. So privilege protects the relationship. What is said doesn't matter. It is the relationship that matters. So you'll see the same thing in attorney-client. Does the client expect that the communications between the client and the attorney will be used to render legal advice? If so, and there's an attorney-client relationship, the courts recognize that. So too, with the discussion we just got through, it's the legislative privilege. And legislative privilege is different than confidentiality, though you can have things that are both confidential and privileged. So as we were wrapping up the last discussion, it ended on the notion that there's a difference between federal and state litigation. And so too, in the treatment of privilege, there is a difference between state and federal litigation. Again, context matters, the state matters, the venue matters, but in general, when you're in state court, the state courts tend to recognize the privilege of its own members of the state legislature, and gives them a great deal of deference. While it's not quite absolute privilege, it's a strong recognition of privilege in state court for state legislators. You're not going to get the same experience in federal litigation, and for redistricting, that's often where this winds up, is in federal court. And what you have to understand is that in the federal court, federal courts recognize legislative privilege as an extension of the grant of privilege and the speech and debate clause within the federal Constitution. However, for a state legislator in federal court, what you see is a common law extension of that doctrine as a courtesy to the state legislators, but it is a much less deferential recognition of the privilege. And so you're not going to see an absolute privilege. You're going to see a qualified privilege with almost a minimal effort towards deference. And in addition, you'll sometimes see federal courts looking at the statutes and constitution of the state to see how does the state itself treat legislative privilege. And they can use the fact that a state does not have statute on point, maybe there's not a constitutional provision, to say, well, even the state doesn't recognize legislative privilege, so why should the federal court extend a greater privilege than the state itself recognizes? So things that you need to be aware of when talking about federal litigation and use of legislative privilege. For the audience in New York, this case here is one of the seminal cases on legislative privilege. It's a redistricting case, Rodriguez versus Pataki out of New York. What the court wound up doing here is saying, well, we recognize that there's a societal value in legislative privilege. However, determining whether or not there was an improper motive in the way redistricting was done is also a strong societal value. So we need to weigh out and balance the two values and see how they preponderate. This test has been adopted in most of the circuits, and this is the test you'll usually see discussed, or a variant where there are 7 factors. But the 5 primary factors start with what's the relevance of the evidence sought to be protected. So if they're trying to pierce the legislative privilege, one of the arguments could be, what happened? Oh, sorry. One of the arguments for Rodriguez on the Pataki test is the relevance of the evidence sought to be protected. If the evidence isn't truly relevant to the question in hand, it is a strong argument for the legislator or the legislative office to say, this isn't necessary, you should not pierce the privilege for this. Availability of other evidence. This is also called the best evidence rule. If the evidence can be gotten from another source and that source wouldn't breach a privilege, go get it elsewhere. Do not breach the privilege here. What is the seriousness of the litigation? Okay, if we're talking about redistricting, you need to know you're going to lose at topics 3 and 4. The government is highly involved and redistricting is very important. Which brings us to the 5th factor, and this is the one where I would suggest to you that if you're wind up in court, this is something you really need to take time to carefully think and plead. What is the chilling effect on staff to know that if they speak up and they give candid advice, that they really are participating in a meaningful way, that if they do in a call to court, they will not do so again in the future. That factor right there is important, and one that I would stress to you is something to consider. How can you protect privileged documents and information? So this is some general advice, and this is stuff I give even outside of redistricting litigation. Be intentional. When you gather up documents, you should have a reason. You shouldn't just vacuum up everything in a room and decide later whether you need it. There needs to be a reason for taking in information and storing it. Speaking of storage, retention. You need a retention schedule. Your state should have resources available, and if it's not, there are resources available on how to develop a retention schedule. These help you determine how long you hold on to documents and what the schedule for destroying those documents are. Very valuable for making sure that you only retain information for as long as it has use in your office. Safe practice for accessing documents. You want to make sure that you're using VPN, you're using a secure login into your network so that information isn't stolen or leaked. When you are requesting information, you should keep a log of it. You should know whether you have it and from whom you got the information. Because it's one thing to say, well, this is privileged, I got it from X source. But if you cannot show how that information came to be into your possession, the court may push back and say, well, you have no proof that this is a confidential source or this was actually gathered as part of the legislative process. You need documentation, so this is an important thing to do, have a really good record. And of course, always ask for legal guidance. Common scenarios I get asked, what if I want to show it to one person and not another? Yeah, that's not how privilege works. You've got to treat people equally situated. Can I establish a relationship with a member to claim legislative privilege, even if I don't work for them? And that answer is nuanced, but maybe. Does a member need that outside party? Is this a regular pattern and routine in which they form their legislation? Then perhaps legislative privilege would attach. General key points. Privilege protects legislative oversight and independence. Privilege is not absolute. Facts, context, and venue and the nature of the relationship will bear out on whether or not privilege attaches. And you should be very deliberate about the way you take and store information, and always intentionality and consistency is key. Quickly, this case has been discussed earlier, so I'm not going to hit it. Bethune versus Virginia, big redistricting case, definitely worth your time to look at. Considerations for 2020 redistricting. Clearly established that the work is legislative in nature. Again, document why you're collecting, why you're doing the work you're doing. It's important to establish that legislative privilege later. If you have an attorney working on a product and you want attorney-client privilege to attach, it's not enough that the person's an attorney. There has to be an expectation of an attorney-client relationship and that the work being done is necessary that an attorney do it, not merely that they have JD behind their name. Set clear expectations when you're relying on technical staff. Again, when doing the redistricting maps, when you're bringing in these experts, that's true. You do need technical expertise. But if you leave them in the room for 24 hours and they hear your attorney-client conversations and they hear all these other conversations, it's hard to say that everything that this person heard is subject to the privilege. So what are the expectations around that technical staff for their project? Privilege only covers core work projects, not your peripheral or ancillary work. Ensure your data is kept on secure servers. Not a fan of dropbacks, not a fan of a generic cloud connection. And always be sure to use encrypted communications option. Zoom without encryption is not a good idea. Any questions?
Stephen, that was just fantastic. I had a little note on the side saying how great that was. I'm guessing that this is something people are going to want to watch a second time through, take some notes. One of my notes is that on retention, you neither want to ditch everything, nor do you want to save everything. What you want to do is have a plan for how you keep your place clean. And my other thought is that maybe what you're telling us is don't leave your home without an attorney at your side. Is that what you meant to impart?
Maybe not. Maybe not at your side, but it's definitely worthwhile to contact an attorney and make sure that you talk through your plans, talk through how you're going to go about whatever legislative project you're going on. Because if you anticipate litigation, and since we're talking redistricting, you probably should anticipate litigation, as Ben said, then you should have an attorney just kind of talking through and making sure that you're following best practices.
Excellent. Thank you very much